Well, welcome back to the Teske Brief. I'm Stephen Teske, retired judge, and this is part two of my analysis of Barnes versus Felix and how the Supreme Court's rejection of the moment of threat rule changes the way police use of force cases must now be evaluated. Now, if you're joining here without having watched part one, I strongly recommend pausing this episode and going back to part one first. And here's why. Part one ends exactly where courts used to stop the analysis, at the instant the first shot is fired. Under the old moment of threat rule, that brief clip is often all a jury would see. Everything leading up to it was treated as legally irrelevant. That framing matters because when you see only the final second, the second when fear peaks, outcomes tend to follow a predictable path. But that is no longer the law. In Barnes versus Felix, the Supreme Court made clear that courts and juries may not isolate the last moment and ignore what came before it. Use of force cases must now be evaluated under the totality of the circumstances, meaning the full sequence of events leading up to the use of deadly force. And that's where we begin in part two. As you watch this next sequence of video, I want you to be looking specifically for instances that a prosecutor could argue in closing, after all the evidence is presented, including the sequence of videos, reflect acts the officer did or could have done to avoid the shooting. Now, ask yourself this. What choices did the officer make as he walked around the vehicle? Could de-escalation, repositioning, or creating greater distance have changed the context? Did the officer's earlier conduct influence the peril that followed? And what did the known facts show at each point in the interaction? Now, these are not academic questions, ladies and gentlemen. They are exactly the kinds of questions Barnes now requires courts and juries to ask when evaluating whether the use of force was objectively reasonable, not just in the last second, but throughout the encounter itself. Now let's play the synchronized video with those four questions in mind. Take a look.
Good's Honda Pilot can be seen blocking a lane on Portland Avenue, a one-way street in Minneapolis's central neighborhood. Good, who lived nearby, stopped her SUV perpendicular to traffic. Phone video apparently taken by Jonathan Ross, the ICE agent who later shoots Good, shows him exiting an SUV parked south of Good. The video was shared with Minnesota-based conservative media outlet Alpha News. He walks around her SUV counterclockwise.
That's fine, dude. I'm not mad at you.
While Ross is circling Good's SUV, we see Good wave a vehicle by through the open driver's side window. She appears to keep waving at a truck which parks closely, perpendicular to Good's SUV. This is Becca Good. Sources close to the investigation confirmed Becca is Renee Good's wife. As Ross walks around the SUV, he encounters Becca, and Becca and Ross appear to be filming each other with their phones. Two ICE agents exit this truck, the one that parked north of Good's SUV. At the same time, Ross rounds the front passenger side of Good's SUV, and Becca Good tries to open that door. The two agents approach the SUV and order Renee Good to get out of the vehicle. One agent attempts unsuccessfully to open Good's door. Good reverses her SUV, and Ross is now seen near the front driver's side. In Ross's phone video, you can hear Becca Good say, "Drive, baby, drive." And we see Renee Good turn her steering wheel to her right, turning the wheels away from Ross. As Renee Good drives forward and to her right, we see Ross pull out his gun and fire the first shot. It appears to hit the bottom corner of the driver's side windshield. Ross fires twice more, apparently into the open driver's side window, as Renee Good pulls away. This perspective...
Now, that you've seen what happened before and up to and the moment of threat, as you saw in the first one, that is the moment of threat, that the 2-second clip you saw in the last episode, that is part one. So The footage shows Miss Good telling the officer, "I'm not mad at you," which, when properly contextualized, can inform a jury's understanding of her state of mind and demeanor as the encounter unfolded. Now, how the jury may interpret her state of mind based on, "I'm not mad at you," that's for a jury to decide. I'm not here to tell you my opinion, okay? I'm not on the jury. Second, all right, the officer who ultimately fired his weapon is shown walking back around the vehicle after initially approaching it, where he initially heard Miss Good say, "I'm not mad at you," and he keeps walking around. You see that in the video. He passes Miss Good after she states she's not angry. That moment, the choice to engage face to face rather than step back or redirect is part of the tactical sequence before any shots are fired. Third, and what I mean by that, let me back up a moment, is there anything the officer maybe should have done, could have done? These are things that, in closing arguments, the lawyers on both sides are going to be pointing out to the jury when they go back into the room to deliberate. Okay? Now, third, at video frame level, we see how the officer positions himself at the front left of the vehicle as it begins to move. Importantly, the wheels turn away from him just before he begins firing. Fourth, the officer draws his firearm as the vehicle continues moving away from him rather than toward him. That sequence matters because Barnes calls for consideration of how the threat evolved, not just that a perceived threat existed in the final instant. Finally, audio captured in the officer's own recording, audibly immediately or audible immediately after the shooting, includes a phrase uttered in the moment, and that was "effing bitch." Of course, I've cleaned it up. You know what he actually said. But while not itself determinative, statements like this are evidence of the circumstances confronting the officer at the time and will be part of the totality analysis under Barnes. Now, under a Barnes informed standard, a fact finder does not zoom in only on the microsecond before the trigger was pulled and ask, was the officer afraid? It used to be that way. Instead, the jury or judge on summary judgment or some motion to dismiss must look at the whole sequence of decisions and actions leading up to the use of force. And they are this. What choices did the officer make as he walked around the vehicle? Could de-escalation, repositioning, or distance have changed the context? Did the officer's earlier conduct influence the peril that followed? And what did the known facts show at each point in the interaction? Now, by expanding the lens in this way, Barnes versus Felix reshapes not just how force is judged in hindsight, but how the causal chain of the encounter is legally assessed. A court evaluating a qualified immunity claim or instructing a jury must now consider whether the officer's own decisions contributed to the danger that later justified or appeared to justify force. Now, that does not mean we foreclose all violence decisions in the field. What it means is that officers cannot rely solely on a narrow freeze frame or simplistic narrative about the last second. So instead, they and courts must confront the full sequence of choices and consequences when determining whether force was objectively reasonable under the Fourth Amendment, including but not limited to what happened before the moment danger crystallized. And this is why Barnes versus Felix is best understood as a compromise. The court preserved qualified immunity as a doctrine, but it cut off one of the most expansive applications using the last second of fear to erase everything that came before. And that has real consequences. You see, under Barnes, juries are now instructed to consider the following. What did the officer know before the shooting? What tactical choices did the officer make? Did the officer's conduct contribute to the perceived threat? And would a reasonable officer, under the same circumstances, have acted the same way? Those questions used to be sidelined, but now they can no longer be ignored. Okay, This also explains why Barnes has been welcomed by people who otherwise disagree sharply about policing. It didn't presume guilt, it doesn't eliminate protections for officers, but it insists on constitutional honesty, that courts look at the whole story, not just the most convenient moment. So when you hear someone say, the Supreme Court didn't change anything, understand this. That's not accurate, folks. It bears repeating that constitutional evaluation of force depends on how courts are required to handle disputed facts, not how commentators wish they were resolved. In fact, while we are producing this episode, another federal officer involved shooting has occurred in Minneapolis. I mentioned that in the last episode, part one, and it was that of Alex Preddy, an intensive care nurse who was shot and killed by federal agents during an immigration enforcement operation. Now, this marks the second fatal federal use of force in the city within a span of a few weeks. Now, as I was preparing this series, I watched a clip from a self-defense expert discussing the Preddy shooting in real time. And what disturbed me about that commentary was the way factual conclusions were being presented as settled. In situations like this, many material facts remain disputed, and it is not the job of commentators, even self-described experts, to declare those facts resolved. Determining disputed facts is the province of a jury, after evidence has been properly presented and tested in a court of law, not the result of watching aggregated video clips. Equally concerning was the continued application of the old moment of threat frame in that commentary, accompanied by a suggestion, in effect, that Barnes didn't change anything. Wow, okay, but that's incorrect. Barnes did not abolish qualified immunity, but it did abolish the practice of evaluating a police shooting in a vacuum, limited to the final instant before the trigger is pulled. Instead, courts must now consider the totality of the circumstances, including an officer's decisions leading up to the use of force. For example, public reporting includes conflicting accounts about whether Mr. Preddy was armed at the moment of force was used, the role of his previous interactions with agents, and whether his actions constituted an immediate threat, facts that different commentators have resolved in different ways without a formal evidentiary process. In coming episodes, we will break down the legal and factual issues in the Preddy shooting, separating myths from what is actually established, what remains in dispute, and how modern constitutional standards require these events to be analyzed. Again, the bottom line is that the Supreme Court declined to abolish qualified immunity, but it reined in how far it can be stretched, especially in police shooting cases. The Constitution does not operate like a freeze frame, and after Barnes versus Felix, neither do the courts. That's not opinion, that's Supreme Court precedent now, and that's how police shootings are now supposed to be analyzed. Now, what you've just seen is the practical difference between a legal system that looks at a single frame and one that looks at the full picture. Part one of this episode is the single frame. Part two, the one you're watching right now, looks at the full picture. After Barnes versus Felix, courts and juries are no longer permitted to freeze the analysis at the moment the trigger is pulled. They must examine the totality of the circumstances, sequence of decisions, movements, and opportunities that led to that moment. And that change matters. It matters because it allows juries to consider whether danger was unavoidable or whether it was created. It allows courts to evaluate reasonableness over time, not just fear in an instant. And it brings the law closer to how real-world encounters actually unfold. But Barnes does something else, quietly and just as importantly. It exposes a larger problem, ladies and gentlemen. Even when courts are allowed to see the full picture, who can be held accountable and how depends on who the officer works for. State and local officers can be sued under Section 1983. Federal officers generally cannot. The judicially created remedy meant to fill that gap, the Bivens action, has been narrowed to the point of near extinction. So while Barnes expands what juries may consider, it does not expand who may be sued. and that raises a serious question about constitutional accountability in an era when federal law enforcement increasingly engages in routine policing inside American cities. In the next two episodes, we step away from video and into structure. Episode 6 explains why Bivens' actions no longer provide meaningful remedies and why the Supreme Court has said it will not fix that problem. And in fact, I have to correct myself. There's 3 episodes. I did episode 7 next that asks the harder policy question of what happens when power expands, accountability does not, and Congress remains silent. But I had to sandwich a new episode in between. So 7 will become 8. But what 7 does is it talks about some history there that helps to explain why we're in the problem we're in and opportunities in the past to fix it and we missed it. And that we don't need to miss it again. And that's what episode 7 gets into, is the solution. Now, those episodes are not about assigning blame. They're about our civil rights framework and how it still fits the world we're living in. The conversation begins next. So, with all that said, this has been the Teske Brief. Until the next episode, everyone, take care and please be safe.